Thank you. Please be seated. Good afternoon. We're here for oral argument in case number SA 21-141 in the matter of Fann versus Kemp, Real Party and Interest American Oversight. These proceedings are being video and audio recorded, so we ask counsel that you please identify yourselves and your clients when it's your turn to give argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. And counsel, we are socially distanced in this courtroom. It's up to you whether or not to wear a mask. Please do remain at your respective podiums. You should be able to see the clock from where you are. If you're not, you can always get up and kind of glance and you should be able to see it. So if there's nothing further, then counsel, proceed.
Thank you, Your Honor. May it please the Court. My name is Corey Langhofer, and together with my colleague Tom Basile, we represent the Senate defendants and petitioners in this matter. I'd like to begin with a factual issue, and specifically, I want to dispel the false choice between relief in this petition and transparency in the audit. It is not true that the only way to ensure transparency is to deny relief. The fact of the matter is this. The Senate has already released to the public copies of the policies that its vendor is using to conduct the counting on the floor of the Coliseum. At this point, the counting is largely complete. It's released copies of the contracts it had with its vendors, of the payments it's made to its vendors. Its vendor has itself released, and the Senate's re-released, records of where the funds came from, the funds that the vendor collected from the public. And of course, the final report, when it's ready, will be released publicly. This is all in addition to...
Let's stop right there, because I've got a quick question for you. The report will be released to the public. Once that report is complete, aren't you or your client, the Senate, going to get all of the underlying data on which the report is based?
I don't know that the Senate will, actually. I would expect, so first of all, the Senate has not received a draft report yet. It is conceivable that an appendix to the draft report will include all of its data, all the underlying data. It's also conceivable that if it doesn't, the Senate will demand that. But those are decisions for the Senate to make in due course.
Does the Senate have a right to have access to those documents if it so requests?
The document, the agreement between the Senate and the vendor has two clauses that, as they've been briefed, I'm sure you're familiar with them. They allow the Senate to access certain of its vendors' records if it's necessary in the Senate's judgment to defend itself in connection with claims about the audit. It does not have a generalized right to access all records of its vendor. In fact, I don't know of, I can't think off the top of my head of any government contract that gives the government the right to access any records of government contractors. That would be extraordinary.
Well, setting aside the contract, Judge Kemp, I believe, found that Cyber Ninjas is the agent of the Senate, and I think you agreed with that. And that being said, what does that mean? Doesn't an agent act on behalf of the principal or under the control of the principal? And setting aside the contract terms for a second, which way does agency cut for or against you?
The agency relationship in this case is defined by the contract. It's not an open-ended engagement like an employee relationship, for example, where the employer presumptively has the duty to control the acts of its employee. In this case, there's a contract that defines what the agent will do. You're going to audit these records. You're going to send a draft report back to the Senate. The Senate will review it, fix it as it sees fit, and ultimately release it publicly. It does tie the agent's hands in some cases. The agent can't make unlimited public comment, for example, on what it's finding. There have been occasions where that's happened, but it's usually been in the context of a hearing between the Senate and the vendor in this case. And so the scope of the agency relationship is just defined by the four corners of the contract here. It would not be, it cannot be said that an agency relationship opens up all of the records of this vendor without ignoring the text of the public record statute. The question in this case, this is a little bit nuanced. I don't know that we've gone into great detail about this in the briefing. But the question in this case isn't whether the data, for example, that Your Honor asked about is a public record, but whether it's disclosable, right? You can have a public record that is not disclosable. Anything that has a substantial nexus to the...
So are you conceding that when we had the stay hearing, you referred to, possible 60,000 records that are already being held, or just in case we order those to be disclosed? Are you conceding that those are in fact public records under the recognized, I don't know, there's no definition under the statute, but under recognized case law?
Well, we would need to review them to see whether they fit the case law's definition.
But your principal argument is the custody part.
Precisely, Your Honor. So we would review them, if necessary, to say this does or does not have a substantial relation to the public function. But, that's sort of a factual determination that would be made later. Here the question is, well, they're not in our custody, so how could the Senate have an obligation to review and produce them?
When you look at the public records statute was amended, it used to talk about in the office of. It was replaced by the word custody. Custody is not defined anywhere in that statute. So, given the electronic nature of this world, what do you believe custody means? The trial court talked about constructive custody. You have constructive custody of the documents because the vendor is your agent. What do you think custody means in this context, in this world where nobody, I have custody of this paper, but those, not my email.
Sure. So it makes sense to broaden the statutory definition from in your office to in your custody, because it's possible that a server for one of the government agencies, for example, is off-site, so it may not be in its office. But the server would nonetheless be within the control of that agency, and that would be sufficient for custody. You have there's an issue that there's one case on and an AG advisory opinion on about whether documents that are in the custody of employees of an agency are disclosable. And the principle there seems to be that possession or custody by a public official is sufficient. There is no authority in Arizona case law for saying that custody by a vendor, someone who is not the government, not a government employee, is sufficient to create custody.
Counsel, you just mentioned that the documents currently held by the vendor and sub-vendors may or may not qualify as public records. To the extent that they may be public record, what obligation would the Senate have to comply with the PRL?
To the extent the Senate comes into possession of those documents or custody of those records, it would need to produce them if they're, there's a substantial nexus to the public function and they're not privileged. It's possible that a claim of legislative privilege or attorney-client privilege, for example, would attach to those.
Let me also ask you this. Let's assume for a moment that the Senate has not engaged the services of vendors and sub-vendors. Would it be required to disclose these documents?
If the documents were in its custody and there was a substantial nexus to the public function and there was no privilege that attached, then it would. I want to be clear about this, though. There is no evidence in the record, and as I understand it, not an allegation from the plaintiffs, that the contract here was set up to avoid disclosure. If it were, then certainly...
I guess one of the issues that I'm trying to get to is, isn't there an obligation on the part of the Senate to determine whether one of its agents is in possession of public records?
No, Your Honor. That's the Stewart case from this court. And that's if you look at the body of case law from, largely from other states, but certainly from the federal courts, applying the federal counterpart to our public records statute, FOIA, that proposition has been rejected. If you're in possession of it, if it's in your custody, you need to produce it. There is no obligation to create a public record. or to acquire public records that you don't have in your
But in
custody.
this case, we're not talking about creating records. We're
Correct.
talking about existing records.
That's correct. But the federal case law and the California decision, for example, says the fact that it exists somewhere is not enough. You do not have to acquire a copy of a document that you don't already have in order to comply with the PRA. Just the practical reason for that, I think, should be obvious. This case illustrates that very well. We have a vendor. We have, I think, 5 sub-vendors. They had, according to one report I saw, more than 1,000 people who participated in the counting of votes throughout this audit. Are we to acquire the passwords for all of their email accounts and all their phones? Are we to acquire not just the copies of Cyber Ninjas, but
How
its
would there be a
sub-vendors?
substantial nexus between somebody's passwords on their phone
So per-
and the government, and the government objective here?
My point was not the password, but some way of accessing the data on their phone in order to find out whether they have text messages or emails on that phone about the performance of the audit functions. Like, are we to go down this path? Because it seems
Understood,
obvious.
but is that really the question here? I mean, I know there's a sort of a parade of horribles here that could possibly develop, and I see that, but it seems like you're inviting us to sort of, if the Senate, to follow up on Judge Cruz's scenario, if the situation were reversed and this was just a Senate staff, I mean, maybe they had to hire, hundreds of people just as staff to perform this, then everything is open to the public. I mean, everything is open to disclosure under the public records law. But just by having a contract in place to flip that to a third party, then all of a sudden you turn off the lights. There's that, to me, that I'm having a hard time figuring out how that complies with the broad purpose of the public records law.
2 thoughts on that, Your Honor. The first is that that same problem confronted the federal courts when they were construing FOIA. And for good reason, they found that the contract terminates possession or custody. The second thought is, we agree with the respondents that there must be a line drawn. Even they don't argue that all public contractors are subject to PRA requests. They I think, concede that freely, as they must, because it becomes unadministrable. You can't have every government contractor subject to PRAs at will, subject to lawsuits and so on. Where we disagree is where that line should be drawn. They say it should be core functions or essential function. We say it should be the question of custody with the line that the legislature chose in the statute itself,
Even if they're performing a legislative activity?
especially if they're performing a legislative activity.
Why?
If you're performing legislative activity, you are categorically immune from claims, from third-party claims.
All right, let's talk about Mesnard and legislative immunity. Of what import is it to your position that Mesnard and his wife were sued in their individual capacities? He was not sued in his capacity as a representative or speaker of the House, isn't that correct?
I'll confess I'm not sure about the answer, but I assume it's true if you're asking it that way.
All right, and so, well, it is true. If you look at the caption of the case, he's not sued in his official capacity. And of what import is that to the decision and to what the Supreme Court is saying in terms of the immunity Mr. Mesnard enjoyed in making decisions as to whether to amend the report, whether to disclose the report, and so forth?
The legislative immunity cases do not turn on personal capacity versus official capacity. And
Isn't that exactly what Brnovich says?
no, Your Honor. Brnovich, we have offered you 2 different views of the Brnovich decision. The view that they offer is that Brnovich limits legislative immunity only to monetary damages for something you perform in your official capacity. The difficulty with that interpretation is that it overrules Fields. Fields applied legislative immunity to a legislative function where there was no monetary damages question. There was injunctive relief. They're trying to get documents from the redistricting commission. And yet they overruled Fields silently while also citing Fields favorably. And if that weren't enough, that interpretation of Brnovich would put Arizona's construction of legislative immunity as an extreme outlier, I think it's fair to say. It's inconsistent with all the federal case law, including the federal case law interpreting state legislative immunity. Our view is different. Our view is, I think, a more coherent way of synthesizing these cases. It is, Brnovich was talking about not the immunity that arises from the speech and debate clause inside the Constitution. The speech and debate clause immunity applies to the legislature specifically. Brnovich was talking about a different type of legislative immunity, not speech and debate clause, but a common law legislative immunity, where they apply, both of them use the term legislative immunity, but the common law immunity only applies to agencies that are exercising some sort of legislative function, but it is not speech and debate clause immunity. And if you take that reading of Brnovich, it is consistent with Fields, which again it cites favorably, and the federal case law.
Back to what is your definition of custody?
If it's a physical object or document that is in the physical custody of the agency.
So is it your ability to access other documents? Is it, I mean, when President Fann responded to the Department of Defense, she said specifically, as a preliminary matter, your stated concern is these records are no longer under the unlimited control of the state and local election officials is misplaced. Goes on to say we have Secretary of State, former Secretary of State Ken Bennett there, and then it goes on to say, I am in regular communication with Secretary Bennett and remain fully apprised of all material developments in the audit. Doesn't that indicate that the Senate is retaining some sort of control over the contractor and getting that information to their specific agent that they've designated Ken Bennett for?
Yes, John, I understand the question. That letter, that exchange between the Department of Justice and President Fann was concerning a very particular type of record. There are records that are protected by a federal statute that relate to the act of voting in a federal election. And so what the DOJ was asking about there was voting machines, ballots, and I think if they had been in their custody, envelopes of ballots and so on. And so the response is based on a clause in the agreement with the vendor that says, while the vendor is performing these functions, the security for the facility and for the items there would be provided by the Senate. So the Senate retained oversight of ballots, for example, the tabulation machines, but didn't take custody of CyberNinja's records about its own activities. So the Senate's in charge of security, including voting implements, but not the records of CyberNinja's.
So is Secretary of State Bennett, or former Secretary of State Bennett, there to simply observe the security measures, or is he there to oversee CyberNinja's performance of their duties under the contract?
He's certainly there to oversee security. That was a function not delegated by the Senate. So the Senate was responsible for security, as it said in the letter to the DOJ. He was also there certainly observing and participating in the conduct of the audit, and to the extent he acquired records of those, the Senate's asked him for copies of those records, has reviewed them and produced the ones that are responsive and not privileged. We plan to do that again, right, because since we request them, likely there's more. We'll go through that exercise with him. I see there's 2.5 minutes left. I'd like to reserve the balance of my time.
Yes, thank you.
Good afternoon. I'm Keith Beecham. I represent American Oversight. The inception of this case dates back to the Senate using its subpoena power to obtain voting machines, ballots, voter information. As we've described in our papers, they litigated several matters in connection with those. And what followed was the Senate's vendor, CyberNinja's, taking control of those materials to perform a function that the Senate indicated it was going to perform. Since then, it's been a parade of really errors that would be comical if it wasn't about such an important topic. I won't reiterate the things you've probably read in the newspaper, but I think it's clear at this point that the auditors for Cyber Ninjas had no experience doing what they're doing, and it's become clear as they've made one interim comment or report after another that's proved to be wrong by the Maricopa County Board of Supervisors. Yes, Your Honor.
I just want to stop you there. Let's start at the very beginning. What is your best argument for the fact that Mr. Langhofer's client has custody of Cyber Ninja's documents? What is your best argument?
My best argument is that ARS 39129.01 B and C, which has no analog in federal law, requires those defendants to maintain records, and they have consciously, deliberately violated that provision of the statute. And so when 39121 talks about custody, the statute's not getting into details about physical custody, constructive custody, or anything else, because 121.01 B and C require these defendants to maintain the very documents that we are requesting. And they cannot, they arguably, perhaps, can contract out to someone else to maintain those documents for them, but they can't then contend when they receive a public records request that they can ignore 121.01 B and C and therefore avoid their obligations under the statute. The judge found that they had violated those obligations, not just the 121 obligation, but 121.01 B and C. And those are the provisions that they must comply with, and when they comply with them, they will have those documents in their possession, no matter what the Cyber Ninjas contract or anything else says. And so that's my best argument.
Okay, and are they required to create documents or simply maintain documents created on their behalf? What is your argument?
They are obligated under the statute to maintain documents that fall into one of two categories. And I'm talking about subsection B. They're obligated to maintain documents that reflect isn't the word, I'll look at this, it says that they're recorded by subsection B to maintain all records reasonably necessary or appropriate to maintain an accurate knowledge of their official activities and any of their activities which are supported by monies. Both of those come into play. In this case, we would only need one of them. But the statute requires them to maintain those, and although in their reply to our response, the defendants argue that this is a mere record-keeping function, some baseline, and as long as we have an email system, we're complying with the statute. That's simply not true, and in fact, subsection C goes on to say that each public body shall be responsible for the preservation, maintenance, and care of that body's public records. And it further imposes the duty on these defendants, and I'm quoting, to carefully secure, protect, and preserve public records. And they're not obligated to get rid of public records without consulting with the state library, because those records might have important historical or other significance. Well, that is precisely what we're talking about here, and I'd like to digress from, I'm obviously going to answer your questions, but I'd like to digress for a moment and talk about what the records are, because we haven't asked for records that by any stretch of the imagination could encompass 60,000 documents. We attached a summary as Exhibit E to our petition, and I'd like to hearken back to that because I think this resolves at least some of their issues about the sky is falling and the alleged parade of horribles. There were 10 requests that are at issue here from our...
Sorry, Counsel, which exhibit was that?
Exhibit A, it's actually attached, I think, to our response. So it is not one of the numbered things because it's a compendium. The actual requests themselves are found at APP Volume 1, 256, and APP Volume 1, 270. There are 10 requests, and they're somewhat duplicative because the May 10 letter went back and clarified or built upon those prior requests. Let me just go through them real quickly, because that's why we're here. The first request asked for agreements relating to the execution of the audit. The second request asked for plans and procedures for accessing and storing and handling the voter information, equipment, and software that they obtained from Maricopa County. The third request asked for budget and cost information. The fourth request asked for documents if there was going to be canvassing, as was contemplated in the statement of work, canvassing of voters, going to their house and knocking on their doors. The fourth request asked for information about how the precincts where that canvassing was going to take place were identified. The fifth request asked for information about scripts or protocols if they were going to be calling voters. Those were the first 5 requests. In the May 10 letter, we asked for communications between Senate Liaison Ken Bennett and any party engaged in the planning, preparation, or execution of the audit. We asked for agreements relating to the planning, preparation, or execution of the audit generally. The 8th request asked for budget and cost information, including agreements with those who are funding the audit. The 9th request asked for plans and procedures for each phase of the audit, including the chain of custody, procedures for tabulation, and the aggregation of audit data. And the 10th request asked for records relating to the registration and votes cast phase of the audit, which are capitalized terms that are in the statement of work that again related to the canvassing and telephoning of voters. So these are the basic documents relating to the audit that we requested. These are documents that I submit squarely fall within section 121.01B and C. They are obligated to maintain these. And the only reason we're playing this shell game about who has the documents is because they violated section 121.01. And Judge Kemp recognized that in his order, and respectfully this court should too. And no one knows whether Cyber Ninjas will give them the documents I just requested because they declined to ask. But Cyber Ninjas is their agent. They clearly have the ability under Section 18 and other sections of the Statement of Work to ask them. And at the end of the day, it's their obligation to obtain them. There's no evidence in the record that they are unable to obtain these documents. They need to comply with Judge Kemp's order to obtain them. They've made no record to suggest that they cannot.
Counsel, let's talk about timing. Presumably there's going to be a final report, or draft report, final report at some point. Why can't the records be disclosed at that point? Maybe a poor analogy, but I think of like criminal type investigations where, the police department will rarely disclose something as a public record until they're finished, until there's a finished product. What makes this different? Why should you be able to get these records when it's not done, it's not over?
The word promptly in the statute, Your Honor, is the difference. I think in Hodai, which is the closest public records case that I can think of with respect to investigations, which I don't think anyone cited, but if you raise the issue, I don't think there's any case that says under a public records statute, under Arizona's public records statute, if a document is a public record and it relates to an investigation, you can wait until the investigation is over. It's either a public record or it isn't. And if it's a public record, and in Hodai was an example, if it's a public record that the police do not want to disclose for legitimate reasons, privacy, confidentiality, et cetera, then they never have to disclose it. But the public doesn't have to wait until the investigation is completed under the statute to receive the record. And a more immediate issue here is that it's why we filed our amended complaint and have filed a second application for OSC. Cyber Ninjas and their subcontractors and the defendants are essentially providing interim reports. They are making statements to the effect of 74,000 people who requested an early ballot, or they got 75,000 more ballots than were requested in the early balloting, and that statement has been transmitted around the globe, is explained in our second amended complaint. They're not waiting for the final report to spread information, disinformation, depending on your view, and we shouldn't have to wait, the public shouldn't have to wait until that report to obtain those records.
Thank you. So shifting to agency for a second, or agency / control / custody. So how do you respond to Mr. Langhofer's contention that custody is defined, or an agency is defined solely by the four corners of the contract?
Well, I would respond by pointing back to 121.01, that the four corners of the contract here give them the authority to obtain these documents because they've been sued and the documents relate to this lawsuit. But even if that wasn't in the contract at all, 121.01 requires the defendants to maintain documents that relate to their official activities or that relate to funds that they are expending, public funds, And here, both of those are true. And so there is zero evidence in the record, and frankly, it strains credulity to suggest that if the Senate said to Cyber Ninjas, give us these documents or you're fired, that Cyber Ninjas wouldn't give them basic documents about how the audit is being conducted, which is what we've asked for. I don't think you get to limit your agency by drafting a document. Here, the document actually permits them to get these records, but even if this agreement said that they are not able to obtain a single document from Cyber Ninjas other than what Cyber Ninjas decides to give them, that would violate the statute, and the defendants should be ordered, and in fact have been ordered, to go obtain the documents. And if it turns out that they can't obtain them, well, that's an issue for the trial court, and to some degree this relates to the issue of whether you ought to take special jurisdiction about this document issue, because I don't think the record is where you would necessarily want it to be. But the reality is we're not in a position where they've demonstrated that they cannot obtain these documents. They haven't even said it, much less demonstrated it.
So
Counsel?
how do you differentiate between third-party vendors' duty to disclose if every third-party vendor becomes an agent of the state?
Well, not surprisingly, this parade of horribles is just that, it's a parade of horribles. There's a procurement code that does not apply here because it doesn't apply to the Senate. There's a provision, and I'm going to have to do this off the top of my head because I didn't write it down, but I think it's 35214, that says that anyone who contracts with the state, at least under the procurement code, it might be broader than that, I don't know, has to maintain the records that relate, the books and records that relate to the work that they did for 5 years after they finished their work. And at request of whatever government agency they contracted with, they have to supply those records to the government at the government's location. So there's a provision already for anyone that ordinarily would contract with the government where the prospect exists that you might have to provide your records. But here, the notion that the sky is going to be falling and everyone who contracts with the state is going to have to provide their records is belied by the substantial nexus test. Here, they have taken this core government function, a function they could only partake in because they issued these subpoenas, collected voter information, and are having their agent perform the function they would otherwise perform.
Counsel,
That's very rare.
now that you're touching on that point, how is the audit the result of a legislative function, but the production of the supporting documents is an administrative function?
Because these are public records. They've admitted that they will give us the definitions the 10 categories I just gave you. If they possess them, they'll give them to us. They admit that those meet the definition of a public record. And if you have a public record, you have to produce it. I'm sorry, I have lost your question in my wordiness. Would you ask it again, please?
Yeah, so my question was, how is the audit itself the result of a legislative function, but the production of the supporting documents an administrative function?
Sure. So because these are public records, they must be produced. That is a ministerial administrative task. It doesn't encroach in any way, shape, or form on these legislators saying or doing anything with respect to their legislative functions.
But didn't the Mesnard case tell us that, in that case, Mesnard's act in releasing to the public was also a legislative function protected by legislative immunity?
It did, and I think you have to read that sentence in the context of the Mesnard case. In the Mesnard case, Representative Shooter sued Representative Mesnard for defamation, and he sued him while they were conducting the trial, essentially, in the House of Representatives to throw out Representative Shooter. And so during the course of that, both in the legislature and to the public, Mesnard released the investigative report that was the basis of the expulsion proceeding that was at that point taking place. The court in Mesnard held that the investigative report that was prepared by this law firm was an integral part of the deliberative and communicative process respecting the House members' decisions about whether to expel Shooter. And the court went on to say that Mesnard's act in releasing the report was protected by legislative immunity because, as they read, Arizona law requires public records in the custody of elected officials to be open to inspection by any person. Mesnard was the person who ordered the investigation, participated in drafting the report, and initiated the expulsion process, and thus he, quote, performed a legislative function by releasing the report. Mesnard's immunity for defamation for publishing the public record in that case, where they were in the midst of expelling a member in a legislative process, is very different than where we are now. The result in Mesnard furthered the public's right to know what their government is up to, and it furthered the purpose of legislative immunity, which is to allow legislators to speak freely and act freely without concern that they're going to be sued for what they say or do. The purpose of the public records law here would be thwarted by construing Mesnard to permit the defendants not to publish these public records. And the legislative immunity concerns at play in that case, where the report was the basis for an ongoing expulsion proceeding, are simply not present here. So I think in Mesnard, the court held that the production was a legislative function because there was legislative activity that was going on contemporaneously that related to it. I don't think that that decision means that withholding a report, which does not implicate legislative immunity, because you're not saying anything, you're withholding the report after all, is not supported by the purposes of the legislative immunity case law and would really thwart the public record statute. The other, I guess, point I would make with respect to Mesnard is really the squaring that with Brnovich case. There, the Supreme Court held that legislative immunity is extended to shield individual officials from personal liability for legislative acts. It has nothing to do with shielding governmental entities from challenges to claimed illegal actions. The Brnovich case is much more like our case, and I think is the short answer for why the legislative immunity doesn't apply at all. The other point I'd like to make, and the time I have also, is with respect to abrogation. Frankly, this is the simplest way to resolve the immunity issue. The legislature, to the extent you consider the ministerial task of releasing an administrative record or a public record, if that could somehow be construed as legislative, it is, the immunity has been waived with respect to the public records law. The legislature didn't have to, but it made themselves subject to the public records law. And I think the parties agree that the legislature can abrogate legislative immunity if they do so explicitly and unequivocally, and they did so here when they included themselves in the definition of a public body. Defendants concede in their reply at page 16 that the legislature merely volunteered to follow the law and adhere to the statute, but they say this is not tantamount to a renunciation of immunity. But they didn't just agree to follow the statute. They agreed in section 121.02 that if they didn't follow the statute, they could be sued. That's what the public record law says. By including themselves in the definition of public bodies and including language in the public records law that permits public bodies to fail to produce public records like the ones we've requested, they have waived whatever immunity they might have had. I think I'm about out of time. I guess the only other points I would make quickly are that the obligation under 121.01 to maintain these documents, to my knowledge at least, doesn't exist in federal law. And so the federal cases that they're citing, which are inapposite for their own reasons that we laid out in our brief, are particularly inapposite here. I respectfully ask that this court put an end to what's happening, this shell game about we don't have our documents, and either decline jurisdiction or affirm the ruling below so that the members of the public can see these basic documents that relate to the audit. Thank you.
Thank you, counsel.
Thank you, Your Honor. I have 4 points that I think I'll be able to make briefly. The first,
Before you get to your 4 points, very quickly, can the legislature abrogate their constitutional immunity by way of legislation?
the immunity applies to individual legislators. And what we saw from the U.S. Supreme Court in Helstosky is that any waiver of the immunity must be express and unequivocal renunciation. We've seen nothing like that here. The best they have is that the previous legislature, not comprised of the current members, passed a statute that never said it would subject the legislature to the jurisdiction of the courts, just said what the rules would be, and that in no way abrogated immunity for the current members and in the aggregate, the body. The first point I wanted to make was that the idea that 12101 requires agencies or government actors to maintain copies of all the records of their vendors has never been the practice in the state. They're asking you to accept a proposition that would result in a conclusion that thousands of government contracts have been failing to honor the public records statute. That's just not what it means. It's never meant that in practice. The second is on the question of legislative immunity. The intuitive idea that the records of one branch should be immune from the oversight from another branch has been acknowledged by this court, except when the tables were turned. This is a case called Arpaio versus Davis. And if I can say in layman's terms, the relevant holding of Arpaio versus Davis, it is that the judiciary will oversee its own records, thank you very much. Notwithstanding the fact that the Public Records Act exists, Arpaio versus Davis says, we're not governed by the PRA, we're governed by Rule 123 from the Supreme Court rules, which is functionally, I think, the same. But the court makes a point of saying, it's not the rule the legislature passed, it's our rule that governs our administration of our records. The same intuitive reaction that gives rise to the legislative immunity argument gave rise to the holding in Arpaio versus Davis. The third point, this distinction that they tried to draw from Brnovich, Abel versus Brnovich, the distinction between monetary damages and injunctive relief is thin. As we saw today in the lower court, there was a hearing this morning, Judge Kemp said the Senate must produce certain records no later than, I think it's 13 days from today, 12 days from today, 13. And if it fails to, you'll have a hearing to order to show cause what should happen. And presumably if they...
Counsel, you're out of time, but I'll let you make your fourth point. You said you had 4 points.
Yes, Your Honor. The fourth point is in reaction to Judge Campbell's question about what is custody exactly. I will give you my best cut at that. Certainly if it's in your physical custody, if you can touch it, you have custody of that. There's a category of records in the modern world that you can't touch, but you can access without the intervention of any third party. So, for example, pulling up an email on a server, you have ongoing access to your email. You can't touch it. That seems to constitute custody for purpose of the statute. Thank you.
Thank you, counsel. We thank you both for your arguments. This matter is now under advisement, and we will issue a decision in due course. We're at recess.